Mr. Chairman, the bill that the substitute just basically changes the words and makes it a little clearer. The bill hardly has any words in it. So, but basically, Virginia is the only state, us and Mississippi, the only two states in America that don't have class action lawsuits at the state level. And this basically would require the Supreme Court to promulgate rules requiring it. They're no more restrictive than the current rules in federal court. If the bill is not effective until July 1 of 2022. It asked the Supreme Court to develop the rules by November the 1st. So the only thing I'll say is Virginia is an outlier. As I said, it's us in Mississippi, that's it. Class actions to promote judicial efficiency. Just to give you an idea, like when the Volvo thing happened in Fairfax County, there were over 400 cases filed over Volkswagen because the people couldn't join the class action. The Chinese drywall case, these things could all be consolidated and brought as one case together. This will solve a lot of problems. This will also supplement a lot of the bills that we passed last session to give people the remedy they need. And a lack of a class action remedy leaves a lot of Virginians vulnerable to fraud. The bill is supported by the Poverty Law Center, the Trial Lawyers Association, Public Justice, the National Consumer Law Center. And I'm happy to answer any questions, but again, we debated this at length last year, and nothing has changed. I believe there's at least 2 or 3 people online that want to speak in favor of the bill.
Okay, who wants to speak in favor? Go ahead. No more than 1 minute, please.
Leonard Bennett, go ahead.
Thank you, Mr. Chairman. I am on the board with the National Consumer Law Center on the advisory council now at Virginia Poverty Law Center, and I look at all the different participants you see here to speak, and they're not, they're legal aid, the public interest organizations, and that is the biggest beneficiary of a change that Senator Surovell proposes, which is to allow a group of individuals to seek relief without making the judge in the trial court, if it so chooses, handle the same case again and again. If a legal aid organization is needing a reform for a group of tenants in an entire apartment complex, all these new employment rights, if there are large damages, those cases really aren't going to be ever appropriate for class certification because they're individualized. But if a judge finds that the superior, the judicially efficient way to handle a group of common cases is in a class, we should join the 48 other states that have been doing this effectively for a while. The only thing I'd note is that the Class Action Fairness Act and other protections would avoid the kinds of classes we don't typically see here in our federal court either, which are these rip-off settlements. The judge can enforce that and the Supreme Court rules could prevent, but it's time that we join the rest of the country.
Okay, thank you, Lynn Bennett. We appreciate your comments. Next.
Brenda Castaneda.
Mr. Chair, Senators, thank you. I'm Brenda Castaneda. I'm the Legal Director of the Economic Justice Program at Legal Aid Justice Center, and we strongly support this bill to allow courts to consolidate actions by a plaintiff on behalf of others with claims rising out of common questions of law or fact. This bill will allow low-income Virginians to vindicate not only their rights, but the rights of other low-income Virginians experiencing similar mistreatment by the same actors. So often when we're able to bring cases only on behalf of our individual clients, unscrupulous defendants view paying out those claims simply as a cost of doing business and do not change their ways. For instance, we've lately had more and more experiences with large out-of-state landlords buying complexes in Virginia and then failing to follow state laws for things such as submetering utilities. And we may only be able to challenge the practice for a small number of folks for a small amount of damages each. These landlords thus have little incentive to learn to abide by Virginia landlord-tenant laws. Likewise, another common issue we encounter is employers failing to pay overtime or skipping final paychecks. And often we only see a few of those employees who are able to find us and ask for representation. So those businesses may consider these just nuisance claims as a cost of doing business, thus continuing to allow them to cut corners and giving themselves an unfair advantage over their competitors who choose to honor labor laws. So we hope that you'll support the bill as well, and thank you for your time.
Great, thank you. Next.
Christy Kelly, please go ahead.
Thank you. My name is Christy Kelly. I'm a consumer lawyer. I'm on the board of the Virginia Poverty Law Center, the Legal Aid Justice Center, the National Consumer Law Center's Partners Council, and the board of the National Association of Consumer Advocates. We all support this bill because It promotes access to justice for individuals who could not otherwise afford a lawyer. The court system should be something where individuals, regardless of the amount of money they have, can get redress for wrongs. A good example would be a predatory lender. Lenders who are online and come into Virginia, take away business from legitimate Virginia companies trying to use loopholes, charging Virginia consumers 900% interest for a $300 loan. Without the ability to enforce Virginia's state usury law, we could only get redress for one person. If we had a Virginia class action mechanism, we could get redress and bring millions of dollars back into the Commonwealth and encourage Virginia consumers to do business with Virginia companies rather than allow out-of-state individuals to come into our state and evade our laws and take money from our consumers.
Okay.
There's got to be a
Mr. Chairman,
mechanism.
Thank
have
you.
these two speakers used up all of the time in
That's
favor of
okay.
this bill?
Next, who's?
These speakers are going
Yes,
for
yes, Senator Overton, I understand.
well over the time limit that has been set.
Thank you. Next,
Jay Spear, please go ahead.
keep it to a minute, would you please?
Mr. Chair, Jay Spear with the Virginia Poverty Law Center, and I would echo what the other speaker said. We support the bill. Thank you.
Okay, Mark Dix.
Good evening, Mr. Chair, members of the committee. Mark Dix on behalf of the Virginia Trial Lawyers Association. We support the bill and echo the previous comments.
Okay, Jeff, thank you.
And also notice about judicial efficiency. Thank you.
Yeah, Jeff Palmore,
Opposed.
opposed. You opposed to it? What's your position, Jeff?
Opposed
For the Virginia Bar Association or what?
for the Virginia Chamber of Commerce.
Oh, of course. All right. Thank you very much. Anybody
Are you
else
ready?
want to speak one way or the other on the bill?
Well, I'd like to
Mr.
speak
Chair,
if that's an
Whoa,
opportunity.
Mr. Chairman,
Yeah, yes, go ahead.
I mean,
Okay.
you gave lots of time to everybody
Okay,
else.
I'm
Let's
saying, does
let Mr.
anybody
Palmore
else
speak.
want to speak on the bill? That's what I'm asking. One
Yes,
way,
I would
one way or
like
the
to
other. Okay, Jeff, you want to say anything else besides that?
Yes, Mr. Chairman, members of the committee, Jeff Palmore on behalf of the Virginia Chamber of Commerce. We're just seeing the substitute now, but I think would actually agree with one of the comments made earlier by Mr. Bennett that one of the big challenges and reservations about these types of cases is the junk settlements and cases brought on behalf of unknown parties.
What's a junk settlement?
Well, that was the phrase used by Mr. Bennett, where I think the plaintiffs in the case, when they're eventually tracked down, they end up just getting a coupon or some settlement for a few dollars
All right.
when they've actually been injured. So if the goal of the bill is to be able to consolidate cases with known plaintiffs for judicial efficiency, then that's one thing that we might be able to support. If the case is to bring class actions on behalf of unknown parties, that's the challenge, because what we've seen at the federal level is that class action lawsuits that are brought on behalf of unknown parties really do a horrible job of being able to find the injured parties and deliver relief to them. And so if the bill is for identified and known plaintiffs, then that might be something that we can work with the senator on. Otherwise, we would oppose the bill. And if there are amendments that can be made to clarify that, we'd support that at this point.
You haven't looked at the substitute? Just posted it, is that right?
Yes, I've seen the substituted. It's not clear from reading it.
Okay, all right. It's not to go into effect to 2022. Okay. Anybody else would like to speak on the bill, one way or the other?
At this time, Mr. Chair, there are no other hands raised.
Okay. Any discussion at this point?
Mr. Chairman,
Yes,
in light of the
Senator
chair's
Overton.
comment
Yeah.
about not going into effect until 2022, and in order to address the chamber's issues, and hopefully we can find a way to substantively address it, I would move that we amend to add a reenactment clause.
Okay, it's been moved that we'd have a reenactment clause and seconded.
Mr. Chair,
Yes, go ahead, Senator Peterson.
I'm going to oppose that motion. We don't know who will be back here next year. We're here right now, and this is a great bill. And you know what? in this moment in time, we're going to pass this bill with this assembly.
Okay. So we got a motion. All in favor of the motion to have a reenactment clause, vote aye. All opposed, no. Oh, I'm sorry. All in favor, say aye if you like the motion. If you don't like the motion, vote no. No. I'm calling it as a negative. Okay, where are we now? Somebody want to make a motion? Been moved and seconded to report the bill. Any discussion? All in favor who want to report the bill as amended, vote aye. All opposed, vote no.
Ayes 9, noes 4.
9-4, the bill is reported.